Okay, moving swiftly on to our next session, which is entitled Advanced Technologies and the Role of the Experts. This panel will discuss the role and challenges for an expert in an industry rapidly adopting advanced technologies and an exponential increase in data as a result of those advanced technologies in construction disputes. The panel is going to explore how the experts are dealing with advanced technologies in order to comply with legal requirements and, of course, client expectations. The chair for this panel is Vivek Kapoor, who is a barrister at 39 Essex Chambers. He acts as counsel and advocate in large-scale, complex and high-value commercial and investor state disputes. He has particular expertise in disputes arising from infrastructure, construction, engineering, energy, mining, and natural resources. Leading directories describe him as an excellent litigator who is always well prepared and has an excellent grasp of facts and law. Before handing over to Vivek, let me remind you about the questions function. Please chime in with questions. This panel, and indeed all of the panels, will be very pleased to receive them. Vivek, over to you.
Thank you, James. Thank you. Good morning, good afternoon, and good evening, everyone. I understand we have a record number of attendees joining from across jurisdictions. It is our great pleasure to be the first panel of this prestigious conference. To discuss and debate the role of experts, I have with me two brilliant experts, Derek Nelson and Ashley Schreiber, who join me on this panel. Derek is a chartered quantities surveyor with 40 years of construction and engineering experience across a range of sectors. An experienced expert in delay, disruption, quantum matters, Derek is both an accredited and certified expert witness. He is a fellow and the current chair of the Academy of Experts. He is recommended in Who's Who Legal and listed as a thought leader by peers and clients. Astonishingly generous, he says, but I think not. Very well deserved. He has been cross-examined and has given concurrent evidence in disputes from Belize to Borneo, Scotland to Singapore, Mumbai to Moscow, and I'm sure a few places in between as well. Ashley is a senior director at Ankura Consulting based in London. With more than 15 years of experience, Ashley has supported clients through their data needs in projects related to a range of issues, including criminal investigations, fraud, civil disputes, and of course, construction. Certified in some of industry's cutting-edge analytics and data review tools, Ashley is able to lead legal teams, experts, and corporate clients through navigating the challenges data presents, and very successfully, I hear. So that is our panel, and let me lay the stage for you. In today's construction industry, there are a number of mega trends, technology being the most important one, and this great growling engine of change has resulted in new materials, new production technology, digitalization of processes, products, systems, and as a result, a new entrance in the market. The industry through technology is also having to respond to climate change and the changing patterns of movement of goods and workforce. This is radically changing the way construction projects are delivered. Now, construction projects are anyways very prone to conflict, and some would say that with all the great efficiencies and benefits, advanced technologies also make projects and sites more rather than less adversarial. So when you have a construction dispute, old-fashioned or with a new complexion, you need to bring an expert. Expert testimony remains the predominant means of evidence in a construction dispute when it comes to all things technical. And on that note, Derek, 40 years of construction and engineering experience, what advanced technologies do you see being adopted in construction?
Thank you, Vivek. And can I just quickly thank Renato for his kind introduction of the Academy of Experts. Construction has long been criticised for its failure to adopt technology and more efficient collaborative methods of working. That is changing. Construction is borrowing from other industries. Contractors in the UK generally operate on a very, very low margin, and investment required for implementation of new technology can be significant. And those organisations need to be confident that adoption brings financial benefit. Or alternatively, they need to be pushed into adoption by either client demand, such as governments around the world mandating the phased introduction of BIM on their projects, or as a requirement for statutory approvals. So some of the technologies being applied now include BIM, Building Information Modelling, various different levels of time, cost, facilities management information hosted within that model. That might be coupled with progressive 3D as-built scans of projects, and you can achieve that by walking around with a mobile scanner the size of a backpack, or it can be done using drones and other automated devices. You can add augmented reality that is visible whilst you walk around a real site via a heads-up display that's built into your hard hat. And you can couple that with the ability for the whole project delivery team to build the project in a realistic virtual world to identify sequencing and other constraint issues before they step onto the actual site. Include attaching GPS trackers to just about anything, crane hooks, equipment, people, plant, and you have suddenly real-time movement being logged across a site that can identify issues with plant and people productivity. And you can access all of that data on handheld devices with the ability to take photographs, record and tag contemporaneous notes as you walk around the site. That is with us today. You know, there are robots out there that can lay bricks, install curtain walling systems, plaster walls, 3D print parts of or entire buildings. Those I haven't personally seen on site as yet. But what all of that technology has in common is it generates an astonishing amount of data. And that becomes a part of the factual project record. It's that record that experts then need to be able to access, analyze, and understand in order to form their opinion. And that is the kind of single most difficult aspect of expert work that has developed over the last 10 years, I would suggest, is that sheer volume, scale, and diversity of information that needs to be marshaled and managed.
Sorry, data, that is a very interesting byproduct of this advanced technology. Ashley, you have significant experience of helping clients navigate data. What can technology do?
Sure, thanks, Vivek. So technology has really advanced significantly over the last 5 to 10 years. On one hand, you have visual analytics tools, which are quite prominent in the market now. And they take data and they analyze it based off of its textual content. So this actually allows users to drill into data by searching concepts and not traditional keywords. So this is a huge change, and it's really developed a lot in the last 5 years, but it's allowing lawyers and experts to formulate workflows in completely different ways. AI analyzes any sort of document that contains text. It understands themes, it understands ideas. So if it's about delays, site instructions, costs, it doesn't matter, they can all be analyzed using these tools. Taking things even a step further, there are analytics tools now that look at emotional and behavioral intelligence. So it actually looks for documents that contain themes like stress or frustration, nervousness, anger. So it actually brings in like a human element to analyzing data. I think the thing that's important to note with tools like this is that they're known, they're recognized, and they're accepted by regulators and governing bodies. So there's full audit trails, there's workflows that are completely defensible from a legal standpoint. And I think that that's an important thing to understand. Now, on the other hand, you've got image clustering and image identification, obviously pretty crucial when it comes to construction matters. So one of the most exciting developments sort of in the last 2 years has been image clustering. So you can take, with the click of a button basically, thousands of images and have them all clustered with other similar images. So this can be a really great way of obviously prioritizing certain sorts of drawings and plans in order to review those first. But actually, in some ways, almost more importantly, it allows you to take images that are junk, because data always contains junk, and it allows you to filter those out. So you're not sitting there reviewing logos, you're not sitting there reviewing icons, you're focusing on the sorts of images that are most important to what it is that you're investigating. And even further than that, there are now tools that actually take images and extract what's inside them. So say, for example, you have an image of a construction site. If you put it through an image identification tool now, the tool itself can understand what is inside that image, and it can give you a certain confidence level. So if you have a construction site, you put it through the tool, all of a sudden it comes out with 99% confidence that there are people within this image, 100% confidence that there are scaffolding, 87% that it's demolition. So that all gets extracted, that can be searched, and that can be a way that you also prioritize your review. So essentially, all of this new technology is allowing you to look and review and analyze images as if they actually had text, like a contract or an email does.
That is very fascinating. I've often heard economists and experts, and even Derek said that in the morning, that construction sector has been hesitant about fully embracing latest technology and opportunities that it brings, which will, unlock even greater productivity and profits. So actually, what are some of the roadblocks within the industry preventing use of more advanced technology? And how does the role of the expert play into that situation?
Well, Vivek, honestly, other industries are just far more developed in leveraging the power of advanced technology. You've got law firms now that at the very beginning of civil litigations or criminal investigations are using tech from the start. They need to understand what's happened. They need to investigate who was involved. And honestly, they need it because they need to set up their best defense. But then where is the construction industry? I mean, for an industry that generates an enormous amount of data that Derek was just talking about, whether it's relating to schedules, delays, or Gantt charts for monitoring progress, it still seems like there's this hesitancy to embrace the different tech that's available. And I honestly think that experts need to spearhead this effort. As thought leaders, they need to trust and embrace advanced technology because it is the most cost and time efficient way to comply with legal requirements and to meet client expectations. I mean, with Derek listing out all the different options that are available, no one person or people can look at every single element of data and analyze it. And at the end of the day, data is data. So it doesn't matter how you use it. It doesn't matter how it's generated. It doesn't change that it can be searched, it can be culled, it should be prioritized, and that you should be utilizing the tools that are in the market in order to do that effectively. Really, by embracing technology, experts can meet the legal requirements in any investigations. But what they can do is they can do it in a way where they are confident when they walk away, they know that they've found the crucial data that they've been looking for and that items haven't really been missed or overlooked.
Derek, looking forward, how do you see the adoption of advanced technologies impacting on the role of the expert?
I think let me take a step back to look forward. If we think about critical path method programming, it was first used in the 1950s, used in construction, large projects in construction, probably in the mid-60s. So it's been around in construction for, say, 55 years. 35 years ago, I would physically measure the work undertaken by every squad on a project every week. That also went to calculate their weekly bonus, so you got told everything that had hindered performance that week, which was in itself a great factual record. So once a month, we would manually calculate the update to the program. That calculation took the best part of a week to do. And we thought that we were actually technologically advanced when we got our first electronic calculator. You have Artemis launched their computer planning software just over 40 years ago, and it was 10 years before I even touched a computer. And to do that, I had to go to a computer lab. It's not something that you had sitting on your desk at that point. Now you obviously have a lot more capability in your pocket and your phone than I would have access to back then. So in the span of my working life, we've gone essentially from quill pens, rolls of paper and abacuses to pushing a button on a computer to instantly update progress on a program that may contain thousands of activities. Now, without wishing to sound like some misty-eyed nostalgic, in that process, we have definitely lost something. The role of the expert under CPR 35 in the UK is to assist the court by providing objective, unbiased opinion on matters within their expertise. And that expert report must, amongst other things, contain a statement setting out the substance of all facts and instructions which are material to the opinion, and upon which that opinion is based. It needs to make clear which of the facts stated in the report are within the expert's own knowledge, and importantly, it needs to say who carried out any examination, measurement, test or experiment which the expert has used for his report, give the qualifications of that person and say whether or not the test or experiment has been carried out under that expert's supervision. So, for recent criticism of an expert failing to meet those obligations, you only have to go back to the end of June and look at a case that was in the TCC in front of Mrs. Justice O'Farrell. We go and have a look at Fabricon versus WM High-Tech project. So a failure in experts' duties to the court can actually result in a cost order against the expert personally. And again, you only have to go back to earlier this year to see that happening. And that expert was ordered to pay some £89,000 in wasted costs. So, faced with complex project programs and reams of delay analysis, it is actually surprising how often that analysis does not correspond with the facts on the project, but it's instead the product of someone pushing a button and the computer says that's the answer. The same criticism can be made of various black boxes, bespoke analysis software, and I have seen commercially confidential program content and assumptions used to calculate disruption entitlement. That lack of transparency doesn't allow experts to meaningfully engage with each other, and it does not assist the court or the tribunal in addressing the issue that is actually before them. And on a more subtle level, not understanding the effect of different settings within the software means that you cannot understand the effect of the data outputs forming the analysis. And hence my misty-eyed comment at a potential loss of doing and understanding. Data analysis using experts in that field to feed subject matter experts such as delay or quantum is appropriate as long as the expert complies with the practice direction and clearly discloses who carried out the examination, measurement, testing of the data that they have then used in order to form their opinion and write their report. And the adoption of new technologies will bring with it the need for new subject experts to assist the court. And those experts need to understand the role and function of an expert. And I suggest that they undertake appropriate training and accreditation through the Academy of Experts. Other providers are apparently available. And for old experts, it's important that they remain current and that their experience is relevant to the matter that they're opining on. So if you've not practiced your profession for 20 years in a developing field, but have instead become a professional expert, does that assist the court? If you look at the comments of HHJ Matthews in Decena versus Notaro earlier this year, it is not the experience of giving expert evidence in court that makes you an expert. Expertise is acquired by doing the thing in question, usually over many years. And I think that's a very important distinction. I have had experts opposite me in delay in construction who maintain nothing has changed in the last 30 years. And the fact that they haven't been on a live project in 3 decades makes no difference. I think that's difficult to sustain.
Terry, you raised a very important aspect of expert evidence. The use of party-appointed experts and experts in general has been this, the subject of much attention in recent years, both in the context of domestic judicial systems as well as international arbitration. Experienced judges and arbitrators have become particularly intolerant of experts without the right experience, expertise, background, and also professional conduct, all the points that you raised. And in some recent cases, the English courts have been compelled to warn parties, their lawyers and experts against unsatisfactory, unhelpful and partisan evidence provided through their experts. You know, the classic dictum of Justice Cresswell in the Agrarian Refab, this is a case of a vessel, has been cited in judgments, and a few times in recent memory. You touched upon some of them. With a rapid increase in the use of advanced technologies in constructions, I see the role of the expert in construction disputes become even more vital, and even more so in international construction disputes where cultural and jurisdictional differences also have a role. In that context, I think the experts will have to bear in mind not only the overriding duty to be independent, impartial, and objective, but also the implied duty to provide straightforward, clear opinions underpinned by factual data. Well, and while I agree that there is ample guidance on the subject, there is the IBA rules on taking evidence, which reflect general arbitral practice, and the more elaborate CR protocol for the use of party-appointed experts in international arbitration. And then there is, the CPR 35, Practice Direction 35, and the guidance, and Section 13 of the TCC guide. However, in my opinion, a recast and a comprehensive relook at the manner in which expert evidence is presented would be to the benefit of the disputing parties and the profession. What is your quick opinion before we open it out to questions? First Derek and then Ashley.
I think very much it's become evident to me over the last few years that there is a very distinct disconnect between common law experts and civil law experts. Now, if you go back to the IBA rules, the CIR protocol, etc., that generally has been adopted in international arbitration. I think when you start talking about domestic litigation, there is usually a very well-defined set of rules for party-appointed experts that is well understood. When you step outside of domestic jurisdictions into an international arbitration, you suddenly take common law lawyers and rub them up against civil law lawyers, and similarly with experts. So you bring your own cultural experience and expectation to an international forum, and you have completely different perceptions. So I have had a number of matters whereby I have been opposite civil law experts from France and Germany, and even just within the continent. And it's an interesting mix, simply because, if you go to Germany, a lot of the court-appointed experts, I'm going to grossly exaggerate here for the sake of effect, and don't be sending me hate mail if you happen to be German. But a lot of the experts seem to be fairly old professors at universities who maybe haven't worked in industry for 40 years. They have an opinion, and they've maybe written a book or two on that opinion, and they carry that with them. So I have seen reports that essentially present an opinion with no substance, no justification, nothing behind it. And when questioned, the response is, I have 40 years experience, that's my opinion, that should be good enough for you. Now, you try doing that in a common law jurisdiction, you would get hung. So it's that kind of expectation. And if you were, I believe, if you were a civil law arbitrator presented by a civil law expert report, you treat that as party evidence. So if you have a mixed tribunal that is partly from a civil law background, a common law background, you then end up with a mismatch between the expert evidence, how that will be perceived by a civil law arbitrator, and how it will be received by a common law arbitrator. And you have those cultural differences and mix that actually create a completely different dynamic within international arbitration, which I thought, truthfully, had all been levelled out and settled by the CIR, rules and evidence, IBA, so on and such like. And then, a year past October, the Prague rules jump out of nowhere. And all of a sudden, it's been clear that for the last 10 years, this has been simmering under the surface And there has been a dissatisfaction to the extent that a group of people have gone away and done something completely different. It's not settled. And it does make for some very interesting discussions between experts, shall we say.
So, at the cost of making it sound like a cross-examination question, you agree with me that an interdisciplinary comprehensive effort would help?
Oh, absolutely. I do think clarity. When a tribunal is set up, there is nothing to prevent them actually setting out and agreeing with the parties the rules of evidence for that particular hearing. So the experts are fully aware of the expectation of them, as are the parties' representatives up front, and therefore you shouldn't have any of these issues. You will have those issues, but you shouldn't have those issues, and if you do, you have a context within which to deal with it. At the moment, that's missing.
Ashley, one quick question, and I will appreciate a quick response. One suggestion to improve the dispute resolution process from the perspective of the expert and expert evidence, considering the volume of data that is being generated and will be generated?
Mm-hmm. Well, I think that the relationship between whoever's helping the expert analyze data and the expert themselves is, I think it can't be underscored how important that is, because at the end of the day, I understand data. I'm an expert in data. I'm not a legal expert. I'm not a construction expert. What it is I know how to help you find what you want, find what you need, and get there quickly. And so I think that it's that relationship that really needs to be strong, because you'll equally rely on each other in order to make sure you get where you need to go.
Wonderful. And before I open it up for questions, an expert friend of mine once told me a very interesting quote by a Swedish mathematician, Dunkels, and I'll leave you with it. He'd said, "It is easy to lie with statistics. It is hard to tell the truth without it." And I think on that note, I will ask James to open it up.
Vivek, Derek, Ashley, thank you very much. What a fascinating session. My most favourite topic at the moment is ruminating how we're all going to live and work in the future once coronavirus has passed. But I think this may well be my second favourite topic. Really fascinating stuff. And that's reflected by the number of questions that we've got. Let me start with you, Derek. To what extent have you come across new types of technology in international arbitration, and how often have you had to deal with them in your reporting? In other words, to what extent has the expert process in arbitrations caught up with the advances on site?
I think certainly within the last couple of years, I have seen quite a dramatic shift in the application of technology. So I mentioned 3D scanning of live projects. I was involved in a project a few years ago that just before finalising and handing over the project, the contractor actually basically sent somebody around the structure and scanned absolutely everything. So what you then had was the marrying of two technologies. So whilst that project did have a 3D model, what you could then do was overlay the 3D model with the actual scan of the project at completion. And suddenly when you were presenting to a tribunal, you were no longer presenting this representation of the project, you were presenting them with a visual of the actual project. So there's always a question, I think, how accurate is the 3D model? Because it is a model, it is a representation, it is not the project. So where you can actually then, as I say, directly overlay the finished product in effect, you are suddenly bringing to life the project and the issues on the project. Now, if you can do that at stages through the life cycle of the project, you suddenly then have an as-built record that captures in detail the issues in terms of against progress, for instance, the illustration of defects. You can freeze all of that. You can actually walk through all of that. You can take the tribunal literally on a guided tour of the project from start to finish as it is actually being built. And they're no longer looking at a rather crude representation. They're actually walking through the structure or the vessel or whatever the project happens to be. And I think that's incredibly powerful.
Let me stop you there, Derek, if I may, because there are questions flying in and I want to get through as many of them as I can. Ashley, to you, if I may, what impact will new technologies have on the nature and number of construction disputes moving forward? Will emerging sophistication in data extraction lead to more consensus around factual issues? What are your thoughts on that?
I think so. I mean, I think that the thing that we can't really escape is that there's an audit trail for everything that we do now. So every email that you send, every document that you open, all of that leads a trail. And I think that that's going to lead to potentially more disputes, but I think also just more transparency, is that when you've got the written record of it and you're not just relying on photocopies from 25 years ago, everything that's electronic, you're really able to dig into those different matters, but do it much more effectively as well. So I think maybe what you're going to see also is that instead of maybe some sort of construction matters or investigations taking years, your time frame is going to get infinitely shorter because you're able to push through so much more information, but really more importantly, get rid of the noise and focus on what you need to, so you really actually speed up the process as well.
Yeah, okay, very good. And question to the panel concerning the use of AI in particular for image clustering and concept searching. Are there any ethical problems that arise with consideration of the cultural or ethic differences?
I mean, I can start this one if that's all right. I think it's important that when you're working in different jurisdictions, obviously you've got legal teams that you're working with as well. So those sorts of legal hurdles, at the end of the day, anything that you do really with your work emails or your work product, it doesn't actually belong to you anyways. And I think that that's an important thing to note. So, lawyers in different jurisdictions are really the ones to kind of get through the soup of the legalese of making sure that what's being collected is being done with the proper channels. But again, the importance with image clustering and really the huge value in the construction industry is that the number of drawings and images that are generated can number into the thousands and tens of thousands. And it's actually getting rid of the stuff that doesn't matter, the stuff that people actually might be concerned about, but it's not the things that an expert's going to want to look at. It's not the construction site, it's not the drawings and the blueprints. So, certainly it's a combination of obviously, jurisdictional legal requirements, but at the end of the day, your work product's your work product.
Great. Comments from anyone else on that?
I would absolutely agree. I think the way the technology is developing and the way data is being extracted, the legal and ethical concerns, I think it's more ethical concerns, I think can be dealt with very well. And most tribunals, be it judges or arbitrators who oversee this process to some extent, have set very clear guidelines on how this data should be managed, how this data should be extracted, and how this data should be actually dealt with.
Very good. Let's move on. Next question. Are these technological advances limited to the larger multi-million developments and clients with deep pockets, or is this something that's accessible to smaller businesses as well? And if that's the case, will this give the larger companies even more of an unfair advantage in litigation or arbitration? Question to anyone.
I mean, certainly from a data standpoint, absolutely not. You don't need millions of documents and you don't need millions for a project in your bank account in order to effectively use data. Now, obviously, depending on the data itself, the size of it, but really the contents of it, the data experts that you're working with should be able to suggest the tools that you can use, but everything is scalable, everything.
Very good. Have any of the experts used system dynamics associated software to analyze disruption in an arbitral context? And are there any arguments for or against its use?
I certainly have, and I would suggest that there are, for the systems that are available at the moment, there are certain obvious difficulties. So, a lot of this, the initial development of systems dynamics, as you probably know, came out of MIT, was bought by a consultancy in the US, was then developed and sold commercially. And when I refer to black boxes, that's essentially what I was referring to. So there was a huge arbitration whereby this system, this approach, was adopted, and the consultants who had presented that refused to explain how it worked, refused to set out to the tribunal even what the algorithm was and how that actually operated. So how you dealt with the variables that were fed in order to get the product that came out the other end. And that just completely lacked credibility. So the experts opposite had no idea what the calculation process was, what the factors were, and how then could the tribunal have any confidence in the output. So, as I say, I think transparency is key, and there are now, there are commercially available software packages that you can access off the shelf largely, that have a whole host of published papers behind them in terms of how they operate, how they deal with certain relationships, etc. That is very important, because otherwise, how do experts agree figures as figures or narrow differences or actually come to a consensus when one thing is just shrouded in mystery and you're just asked to accept what the answer is that comes out of the computer? I think that's a real problem in that field and others.
Very good. And just a final question, if I may, to Vivek. Maybe this will chime with him better than it will the others. For us non-techies, how do we sort the wheat from the chaff with all these new technologies?
Well, I think it's going to be a difficult process, but one way to do it, and sometimes do it effectively, but it might be a case for a bigger project, is having a shadow expert, and putting that distance between you and the expert who's going to give evidence, because it will have two advantages. There is no sort of danger of his evidence being contaminated, and secondly, the advocate can be properly prepared for the hearing. Very good.
Well, look, it remains for me to thank you, Vivek, Derek and Ashley, for a fascinating session. The questions certainly reflect that the delegates are interested. They've been flying in. I'm sorry we can't get through all the questions. There are near 2,000 people online, so there are a lot of questions coming in. But thanks to you for that interesting session.
Thank you so much.